Hi, my name is Charlotte Harris. I will discuss the consent form from West Texas Counseling and Guidance Facility. I will call them WTCG for short. This consent seems to be in alignment with the framework the American Counseling Associations has provided. Certain areas the ACA recommends to be included will be outlined in the WTCG counseling agreement. They give a description of the therapist in their agreement and their therapist credentials, and then go into detail about the therapeutic relationship and rules within that relationship. The consent states the goals, purpose, and techniques of the therapy, and also explains that the client's input is necessary and welcomed when we're talking about treatment planning. In regards to confidentiality, the agreement states that no information will be released without the client's written consent unless mandated by law. Possible exceptions to the confidentiality rule, which would be in cases like child, elderly, or disabled persons abuse, abuse of patients in a mental health facility, sexual exploitation, and child custody cases. The consent goes on to talk about the duty to warn, stating that in the event the therapist reasonably believes that the client is in danger to physically or emotionally harm themselves or harm another person physically, that the consent is given to the therapist to warn the person in danger and to contact any person in the position to prevent the harm of the client or any other person. And the people to be included and notifying, it could be law enforcement and other medical personnel. Moving forward, the consent speaks about the risk of therapy and how disclosing certain information may be uncomfortable, how and lead to negative emotions. They speak about even the risk of marital therapy being a possibility for divorce. WTCG discusses the definition of an emergency and how they are available for crises care on a 24-hour, 7 days a week per week basis. The consent provides the emergency number as well. This consent talks about if the therapist becomes incapacitated or dies during the course of treatment as outlined by the ACA. There is a consent to treat, which means that the client voluntarily agrees to receive mental health assessment, care, treatment, or services. The next part of the consent is a notice to the clients of the facility privacy practices, and under what circumstances their health information may be disclosed. They stipulate that they have a legal responsibility is to make sure that the client's notice is given notice for the privacy practices. WTCG lists possible reasons why the facility would, with authorization, disclose health information, like to communicate with the physicians and other healthcare providers treating them, or to anyone of the staff of that facility involved in the client's treatment program. They might have to disclose to receive payment from a third party, or they would also have to disclose to anyone that the client may have given written authorization to have their health information. The Privacy Act also goes to speak about the rights that each client has. Some of these rights are fairly basic, like requesting a copy of their chart or requesting how or where to submit a written complaint if they have one. But the other patient rights seem to be quite complicated, and I think it would be kind of discouraging if I was the patient to read it through, because it's really difficult to understand. You feel like you have to have an attorney there. The reference article is the use of multimedia technology in the doctor-patient relationship for obtaining patient-informed consent, 2016. This article suggests of using technology in order to attain informed consents better. Like being able to use video and audio recordings may help enhance the understanding of the client and therefore making the consent not appear as a series of loopholes to protect the counselor, but as a way to keep the client informed of their legal rights and due processes while they're seeking therapy. That's it, and thank you so much.